Next case up for argument this morning is State of Ohio versus Donald Lee Jenny Jr., case number 18CA0041-M. Both parties are represented by counsel and present. Each party will have 15 minutes to present their arguments. Appellant, as you know, can reserve up to 5 minutes. If you're going to reserve time, let me know and I'll keep you apprised of where you're at. The arguments, as you both know, are recorded and posted on the court's YouTube channel, so please keep your voice up. We've read the briefs and are ready to proceed if you are.
Yes, Your Honor. May it please the court. I'm Attorney Joseph F. Salzgaber, and I represent the defendant, appellant Donald Lee Jenny, in this matter. If I may have a scratchy throat, so I would ask the court's permission to use a lozenge.
Absolutely.
This matter involved...
You'll reserve some time?
Yes, I'll reserve 5 minutes of my time, Your Honor.
Thank you.
This matter involved a traffic accident on a snowy day. It was a one-car accident in which my client slid off the road during snowy conditions in January of 2018. Medina police officer responded to the scene, and as my client attempted to explain what happened, the officer was more interested in trying to determine if there was an OVI that had taken place. Ultimately, my client was taken into custody, charged with OVI and with failure to control despite the snowy conditions. There was never any blood breath or urine sample taken from my client. He explained that he was on the only medication he was on was blood pressure medication. As a result, when he came to court, he was referred to the public defender's office, Medina County Public Defender's Office. The public defender screened him, entered a written plea of not guilty, ultimately filed a motion to suppress in this matter, which the trial court denied, even though it was more than 4 weeks before trial. It was technically untimely filed under Criminal Rule 12D because it was 35 days after, technically 35 days after what should have been an arraignment hearing, but he was not arraigned at that time. Our argument in this case is that the court erred and abused its discretion by denying Mr. Jenny's motion to suppress as being untimely filed. Well, first of all, there was no arraignment hearing that actually started the clock. Now, I realize there was a motion, a written plea of not guilty filed, so technically that could have started the clock. But nonetheless, no arraignment hearing was ever held. As I indicated, the motion to suppress was filed 4 weeks before the scheduled trial date. It was if you went from the original initial appearance, it was day 43. So we're not talking about the motion to suppress being filed weeks and weeks after the expiration of time. It was on day 43. The state of Ohio objected on, it was March 8th of 2018, the very next day after the suppression was filed. The state did not indicate that it would be prejudiced in any way at all. It just said that it was untimely filed. That was the basis of their objection. Later that same day, on March 8th, the assigned public defender filed a response stating the reason for the untimely filing as being that the public defender's office had been short-staffed for several months. They had one public defender doing the work that was normally assigned to 2 in the Medina Municipal Court. So a reasonable explanation for the request in the interest of justice to allow the untimely filing was provided to the court.
Had a trial date been set at that time when the motion was filed?
I believe the trial date had been set at that time. It was 4 weeks out, which, as I'll discuss, the case law indicates that when the trial date is still rather far out, and in 4 weeks is not a long time in county police court, obviously, but in municipal court, 4 weeks is quite a lengthy period of time, or can be. And not resting on his laurels, the public defender went to pretrial, further discussed with opposing counsel and with the judge the suppression issue. The judge then basically invited the public defender to file a motion to reconsider on the motion to suppress. He outlined the basis, and there seemed to be a reasonable basis for a motion to suppress. You did not have, as I indicated, any tests which would have been definitive of whether or not Mr. Jenny was in fact under the influence of drugs or alcohol. There was a challenge to the basis for the arrest. I mean, obviously, his vehicle was in a snowbank, so there was no traffic stop per se. But you had a reasonable basis for a motion to suppress, which the court unreasonably, and we believe, abused its discretion in denying.
So the argument on the motion to suppress, if it had been heard, would have been probable cause to arrest?
Would have been probable cause to arrest and to conduct the sobriety tests. Given that you had someone standing at the scene, the officer indicated there was no odor of alcohol at all. You just came upon someone whose vehicle was in a snowbank on a snowy day in January.
Remind me, were there field sobriety tests conducted, and if so, how did you do?
The HGM test was conducted. And I believe other field sobriety tests were conducted. The individual indicated that he was on blood pressure medication. It was cold and snowy outside at that time. The public defender, frankly, did a very good job in his motion to reconsider the motion to suppress. He citing the cases of State v. Bryson and State v. Garrett, one out of the 2nd District Court of Appeals from 2015, and the other out of the 5th District Court of Appeals from 2017. They discussed the issue of denying untimely filed motion to suppress based solely on the fact that it was untimely. And those courts indicated that basically if there's still time left, it's still quite a distance away from trial, and the state does not articulate a valid reason for denying the delayed motion to suppress, it should be permitted. In this case, the judge denied that. He indicated that no good reason was shown. We would argue that it was an abuse of discretion not to allow a potentially dispositive motion to suppress to be filed when you still had 4 weeks away from trial.
Let me ask you, counsel, do we have to look at prejudice on this issue? I know we have to look at prejudice for your second assignment of error with ineffective assistance of counsel, but if you had a baseless motion to suppress, does it really matter if a continuance wasn't granted?
Well, that's a good point. I mean, if it was simply a canned motion, which you filed in many cases just to preserve the time and not get beyond the 35-day time period, I would agree with you. But in this case, it's the burden seems to be on the state to articulate that it would be prejudiced by an untimely filed motion. We're talking 8 days. If we take the state's argument on its face, this motion was filed on day 43, 8 days after the 35-day time limit. And the state merely stated in its opposition to the untimely filed motion that it was untimely filed. So that was their basis, no articulation of any prejudice on the part of the state, no indication that the only officer who would have been a witness was unavailable, nothing of that nature. And as I indicated, this was a potentially dispositive motion in that the officer did not observe any erratic driving. He merely arrived on the scene and began conducting an apparent OVI investigation. And as once again I indicated previously, there was no blood, breath, or urine test offered. So we would ask that the first assignment of error be sustained in this matter, reversed and remanded to the court to hold a hearing on the motion to suppress. With regard to the second assignment of error, if this court, this is basically being argued in the alternative, if the court determines that there was no error in denying the motion to continue, trial counsel provided ineffective assistance of counsel under the Sixth Amendment to the United States Constitution by failing to file a likely dispositive motion to suppress in this OVI case, which resulted in dismissal of that motion without a hearing and waiver of the issues involved. If there was, in fact, no abuse of discretion on the part of the trial judge, the fact that the public defender filed this out of time so that the issue couldn't even be brought before the trial court, that falls below the objective, reasonable standard of representation. And I believe that there's numerous cases which involved the analogous issue of someone not filing a brief in an appellate case. Well, if you don't file a brief, you've provided ineffective assistance of counsel per se, because there's nothing for the court to look at or decide upon.
Now, I want to keep hearing from you, but you are at 4 minutes and 57 seconds as we, at this point, so.
Okay.
You can continue or?
Yes, I'll continue.
Okay, very good.
Mr. Jenny was prejudiced by deficient performance because his meritorious and likely dispositive motion was not heard by the court. As I indicated, the officer did not have reasonable suspicion based on the fact that the car had driven off the road on a snowy day to administer the field sobriety test. There was lack of probable cause to arrest Mr. Jenny. And there was a lack of lawful basis to search the vehicle as a result of all of that. As indicated, it was after dark on the Sunday evening, 6 p.m., January 14th. He was an icy, snow-covered road as he attempted to turn from Lafayette onto Prospect Road just south of here. The officer did not observe Mr. Jenny driving, but arrived afterwards. The officer, Officer Brink, admittedly did not detect any odor of alcohol emanating from Mr. Jenny. Mr. Jenny advised he did not drink and was only on blood pressure medication, and there were no field sobriety tests. Attached to the actual motion to suppress that was filed was a case rendered by this court, State v. High, which indicates that it was a meritorious motion to suppress. If this court followed its decision in State v. High, we believe that there would have been a suppression of the evidence in this case.
High was kind of a unique circumstance. Basically, the state didn't bring in a witness that would have closed the gap in what they needed.
Well, I mean, no.
I guess I'm not asking. I'm
Right.
just making
No
a
two
point.
cases are going to be precisely identical, Your Honor, so I acknowledge there are some differences between the cases. But High indicates that this was a meritorious motion to suppress that was not heard due to the deficient performance of the public defender, and that Mr. Jenny was thereby prejudiced in this case. His constitutional rights were violated. Based on the foregoing two assignments of error, we would ask that this court reverse with respect to one, or if the court finds that the trial court did not abuse its discretion, that proceed to the second assignment of error and determine that, in fact, there was ineffective assistance of counsel provided in this case.
2 minutes and 18 seconds. Obviously, you have 15 minutes.
Thank you. Police Court, my name is Greg Huber. I represent the state of Ohio in this case, and we respectfully disagree with the appellant's argument. This court has looked at the issue of filing a motion to suppress a couple of times with some pretty clear pronouncements as to what this court typically has required. These cases are cited in our brief. The one case is State v. Bodie Arms, the other is the Pelosi case. Essentially, as it involves a motion to suppress, this court has looked at Criminal Rule 12D that states a motion to suppress should be filed within 35 days after arraignment or 7 days before trial, whichever is earlier. And then if defense counsel cannot meet that timeline, this court has asked and required that you file a motion for leave to extend time within which to file a motion to suppress. Or if you don't do that, this court has required that you state in your motion to suppress with some evidentiary support reasons for why the trial court should consider extending the timeline. In this case, neither of those things occurred. The defense counsel did not file a motion for extension of time, and the record clearly establishes that prior to filing his motion to suppress. And if this court looks at the motion to suppress that was filed, there is no explanation as to why the defense counsel is filing outside the rule. I think that provides order to the problem, because if you don't have some manner of dealing with this issue, trial courts are faced with motions filed 8 days at a time, 2 weeks at a time, and essentially a trial judge, if he doesn't have a procedure on how to deal with the criminal rule 12D time limit, you really do end up putting your finger up into the wind and coming down with an answer that probably doesn't have, or could be attacked or challenged. I think this court's analysis is good. I think this court's case law puts defense counsel and trial counsel on notice that you need to do more than simply file a motion to suppress out of time, given the fact that our criminal rules do prescribe a timeline. I think it's reasonable, if our criminal rules have a time deadline, that trial counsel requests an extension for leave to file out of time. And I can tell you that our trial court grants those regularly, and I think most trial courts do. That's not the end of the inquiry. This court actually gives trial counsel a second bite at the issue by allowing and expecting that if you're going to file out of time, at least put in your motion to suppress an explanation as to why you're out of time. The trial judge in this case is attentive to what this court expects. He looks at this court's decisions. In his order, he reviewed the Pelosi case, the arms case, and he cites exactly the language from this court with respect to the issue. In the Pelosi case in 2007, this court wrote, "Here the defendant filed a motion to suppress on March 29, 2006, 49 days after he was arraigned. He did not attempt to establish that he had good cause for untimely filing of the motion to suppress. Neither did the defendant move the court for an extension of time to file his motion to suppress. Only in his motion for reconsideration did the defendant address the timeliness issue." Now that factually is exactly on point with what happened here.
I'm sorry, counsel, I thought they addressed it in their response to the state's motion in opposition.
That's what happened in Pelosi.
I thought they didn't address it in Pelosi till the motion for reconsideration.
And that's what happened here.
Did they file a response to your, when you filed your motion in opposition, didn't they file a response to that?
No, it was a motion to reconsider, as I recall. Now, I could be mistaken on that, because again,
I thought I'd read that, but I could be mistaken as well.
My recollection is that the explanation came in the motion to reconsider. The court here states that only in the motion for reconsideration did the defendant address the timeliness issue by asserting that the motion was filed untimely because of the difficulty being able to review a videotape. The court finds that the trial court properly denied the motion to suppress in terms of the timeliness issue. And this case and the O.D. Arms cases are the two cases the trial court here looked to for guidance as to how to deal with this question. I think the procedure that this court has asked for is reasonable. The trial counsel in this case did not follow either of those outlines, and accordingly the the trial court level denied an extension of time for filing the motion to suppress. The second issue raised concerns effectiveness of counsel. I don't know how the court can properly rule on that in this case. This court outlines a question in the case State of Ohio versus Davis, and there is a requirement that defendants show that the defendant's been prejudiced by the deficient performance of the attorney. And so essentially there has to be a record for this court to look at, and in this event, both with respect to the motion to suppress and its untimeliness and the question of probable cause facts, there's no affidavit, there is no testimony, there is no record. Frankly, even in the motion to reconsider explaining the untimeliness, there's no affidavit, there's simply statements from counsel. I don't think that's a proper basis for asking a trial court or an appellate court to make decisions concerning factual issues. If you look at the appellant's brief in this case, he argues the probable cause issues, and if you look at my brief, because I have the police report, there are a whole bunch of facts pertaining to witnesses who saw erratic driving. Our arresting officer in this case was nearly run down when the defendant backed up his car without looking where it was going. There was facts that caused this officer to pay more attention to the defendant in terms of what he's doing and what his problems are and why he was having problems, none of which were heard through testimony and none of which have been set forth before this court in a proper record. Consequently, I don't see how the court can make factual findings at this point, given the fact that you'd have to find that the defendant might win his suppression motion. Well, how do you determine he might win? You'd have to have some kind of record.
Are you saying because he pled no contest, basically I understand that if you plead no contest, you can still preserve your motion to suppress, obviously. But if you don't have any basis on the record for that.
Right, even in the motion to suppress, there's no affidavit attached, there are arguments presented by counsel but no evidence. This court said in the Edward J. Davis case, and this was on the question of effective assistance of counsel, this court said, because we do not know what credible evidence would have been presented at a suppression hearing, Mr. Davis cannot show that he was prejudiced by his lawyer's decision not to file a motion to suppress. We conclude that Mr. Davis's argument is more appropriately made in a petition for post-conviction relief because there he could present a complete record regarding whether Officer Wagner had reasonable suspicion to stop him. There is no record in this case, only arguments of counsel. I can tell you right now that I've got plenty of arguments about what happened in this case to why a police officer might think there was something wrong with this defendant. But that doesn't help you. It's not a sworn statement for me. There needs to be a record if this court's going to review this issue properly, and there isn't. So for these reasons, we would respectfully contend, number one, the trial court assiduously looked at this court's decisions on how to address timeliness of suppression motions and followed this court's requirement. And I think the trial court did so appropriately. And number two, there's not a record for determination as to whether or not there's effective or ineffective assistance of counsel. So for these reasons, we would ask the court to deny this appeal, and I much appreciate your time and attention.
I'm sorry, I have a question before you sit down, if you don't
Yes.
hear. I want to ask you the same question I asked appellant, and that is, on a regular motion to suppress that is filed untimely and the trial court denies the leave to file the suppression motion, on appeal, does the appellant have to show prejudice as a result? Obviously, we only deal with reversible errors, so I'm trying to figure out, does he have to show prejudice? In other words, that the court would have been likely to have granted the motion to suppress if it had been filed timely? I know they do on, I'm sorry, I keep stopping you. I know with ineffective assistance of counsel, but I'm talking about the first assignment error.
My statement in response to that is that there is a requirement that the appellant show prejudice. The case that addresses that is Akron v. Milewski. It's a 9th District case where it says that the appellant must show abuse of discretion, which is more than an error of judgment. The appellant must demonstrate, quote, perversity of will, passion, prejudice, partiality, or moral delinquency. You bring up the word prejudice. If I follow the logic of the Milewski case, this court's requiring that an appellant is going to establish abuse of discretion. There is a burden on the appellant to show prejudice. Again, there's no record to properly be able to determine that issue at this point. Thank you.
Thank you. Counsel, you have 2 minutes and 18 seconds.
I will probably use all of that. In response to Judge Carr's inquiry before, the timeline was that there was an allegedly untimely filed motion to suppress on or about March 7th of last year. Later that same day, the prosecutor filed a very short objection on the grounds that it was not a timely filed motion to suppress. That was the only basis for their objection at that point. The very next morning, the public defender filed the response to state's objection. And in that response, the public defender, on behalf of Mr. Jenny, requested an extension of time, cited 12D that the court, in the interest of justice, may extend time for making pretrial motions, and further explained that it was the lack of staffing or understaffing on the part of the public defender's office was the reason why it was filed on day 43 as opposed to within the 35-day time limit. We're dealing here, Your Honors, with an indigent defendant. He's relying on the public defender. It's very clear from the record that it was the fact the public defender was short-staffed with only one lawyer covering the court when only 2 lawyers would cover that court. That was the reason for the delay. So in summation, Mr. Jenny should not be penalized for short-staffing on the part of the public defender's office as an indigent person. And it was unreasonable for the court, the trial judge in this case, not to grant the extension of time, knowing that Mr. Jenny was indigent and that he was relying on the public defender's office. With regard to the second assignment of error, I believe the fact that he didn't file this, it was clearly something that he attempted to file. The fact that he didn't file it timely in and of itself is ineffective assistance of counsel. And I would analogize that to someone not filing an appellate brief after the lawyer is retained or appointed for that purpose. Although there's nothing in the record, the mere fact that nothing was filed and the lawyer didn't do anything, that in and of itself was found to be ineffective assistance of counsel. So we would ask this court to reverse and remand back to the trial court.
Thank you both for your arguments today. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail each of you a copy of the decision on the day it's released, and you both know the Supreme Court of Ohio also posts the opinions. Thank you both again for your arguments.
Thank you.